My name is
I'm here.
Eric Jones. Eric Harris.
All right, what are we doing now?
Your Honor, we have two matters up. I have prepared and signed a request for screening into the 15th District Mental Health Court. Actually, I need to absolutely.
And how long is that taking, you think?
Your Honor, they meet every other Wednesday, so maybe 3 to 4 weeks.
3 weeks.
They just met, yes. I attended, it was yesterday.
Probable cause conference, October 31st, 2024, 9 a.m.
Your Honor, support received progress report from community corrections that indicates the defendant was testing at Ann Arbor Treatment Center has had positives at that facility. I think the report was dated October.
I have that. He actually has a bond out. He actually has a warrant out at this point.
Yes, Your Honor, if I may address that.
Go ahead.
Your Honor, Mr. Harris, there was the testing information. He came to my office on Monday morning. We discussed the matter with or Tuesday morning, I can't remember now. We discussed the matter with his provider at the treatment center. He informed us that Mr. Harris is prescribed methadone and it's provided for him there. He also said that he had provided a new test to community corrections that was dated October 9th, I believe, that or October 7th, that was clean for things that he was not prescribed for. And I reached out to the agent and to see if he had the tests, and he hadn't. I believe Mr. Harris would, if the court wanted to test him today, would likely come back negative. I'd ask the court to consider.
He'd come back negative today?
Yes, except for I think for the what is it called?
Methadone.
Methadone. Sorry, Judge, but in talking to his agent there, I guess. In certain circumstances, fentanyl can stay in your system for some time. But I believe he's had a negative test recently for fentanyl that his agent advised that he had sent over to community corrections. Yes, Judge, I have seen those, and I believe there's an October a more recent test than that is negative.
And Your Honor, I do believe that people have received the same documentation. This is not a format that I am personally accustomed to receive drug results in. However, it is my understanding that it indicates the positive urinalysis on the 9th, November 10th, November 18th, November 26th, each for methamphetamine. There also could be positive tests from
Yeah.
the methadone is a separate test, which is under here as MTAB versus MTAB, I believe. I believe MTAB indicates methamphetamine. My best understanding, it may or may not, but the MTAB is what I believe indicates methadone. I believe that's different.
It is.
And then I also see, if I'm reading this correctly, positive fentanyl tests from 8/28, 9/9, 9/10, negative on 9/18. Which is interesting. And then positive on 9/18.
Your Honor, if I might, I believe the meth portion is methadone, the MTAB. In speaking to Kenneth Hammond from the treatment facility, the meth is methadone and the MTAB is a metabolite, and the fentanyl is fentanyl. That's
Okay.
my understanding from speaking to him.
But why is fentanyl showing up?
Your Honor, that Mr. Harris Jones is currently on tether. He is working to maintain sobriety. I believe his latest test, where we did, and Mr. Hammond said he sent it over to community corrections. I can call and see. I had hoped the court would have it. Was negative. He reported that to me earlier.
Right, but all that's going to tell me is that it's periodically using, because the one before that on the 18th is negative, regarding fentanyl, but then the 26th is paused.
Can I speak, Your Honor?
If you want to.
Yeah, never mind.
Yeah.
But I'm not using periodically though.
Pardon?
I'm not using periodically. That was just, never mind. Go ahead. Never mind. Go ahead. All right.
Your Honor, as I said, he is in a program. He is, I believe he is endeavoring to work his hardest at it. His latest test would be negative. I'd ask the court to consider admonishing him not to use to continue testing and to stay within the parameters of the treatment program that he's involved in currently. He has several things going for him. He does have a meeting next Tuesday on the 15th at 3:00 with Community Mental Health. He's been going through their screening process. This is with the housing people.
Okay. I don't have a problem with any of that. But what I'm going to do at this time, I'm going to remand the defendant $25,000 cash surety bond on each case, which was the bench warrants that I set. And then once he is looked at by the folks at, I will reconsider that. I don't have a problem doing that, but there doesn't seem to be much that's kind of holding him in at this point, and that's what concerns me.
Thank you, Your Honor.
I'll set it for the 31st at 9 a.m.
Thank you.
Assistant Public Defender Natalie Pate with an on behalf of Mr. Hook, who is approaching the podium. Please state your name for the record, sir.
Roger Cook.
Go ahead.
Thank you, Your Honor. Today is the date and time set for both a bond violation as well as a pretrial in this case. As to the pretrial in this case, people have made an offer to be held open through today's pretrial of plead to count 1 under 4A and count 2 would be dismissed. I have had an opportunity to discuss that with my client a few times, and he does not wish to accept that offer and would like to set the case for final settlement conference. And as to the bond violation, he does acknowledge the first one, but we do admit to the second bond violation dated, I believe, the 31st of October.
So he admits to the, say that again?
He does not admit to the first bond violation, but he does admit to the second bond violation, which I believe was the 31st dated bond violation. He does admit to that bond violation, but I would also like the contact, Your Honor. Yes. And I would also like to address bond when appropriate.
Yes, Mr. Allen.
Oh, may I proceed, Your Honor?
Yes, go ahead.
Thank you, Your Honor. Mr. Hook has been very involved in his case and speaking with me and in his defense. He was very honest and did admit to this bond violation. He does understand that he messed up. He does understand that he should not have had any contact with her in any capacity after your court or changed the bond condition on October 18th. He does acknowledge that he violated that bond violation and he was wrong in doing so. However, he does state that he has not had any contact with her since that last alleged bond violation, that he will further not have any contact with her pending this case. He does have full-time employment and he's been there for 4 months. He works directly under the foreman as a lead operator with Lawrence and Clark, and he does have a full-time position there. Outside of these alleged bond violations, he has been in compliance with his GPS tracking, which he is currently still on tether for, and he does reside with both of his parents during the pendency of this case. We're asking Your Honor to allow him to remain out on bond while this case is pending, as he does continue to maintain his innocence in the underlying charge and is hoping that he will be allowed to continue working while this case is pending.
Ms. Lundy.
Thank you, Your Honor. The people are requesting that the court remand the defendant without bond pending his final conference date on December the 6th. The reason for this is multi-factor, and I'll start with the earliest. July the 22nd, this defendant was present with the defense attorney, Ms. Pate, and the victim requested phone contact for the defendant to have contact for child exchange, parenting matters, upcoming family birthday party. The court modified the no contact order to allow that contact. Then when we were next here on this September the 9th, we set the final settlement conference dates. Now the final settlement conference was set for October 18th at 9 o'clock in the morning. If the court will review the bond violation report, there was a message sent by the defendant to the victim on October 18th at 9 o'clock in the morning that says, do you realize you being here, I'm going to jail today. That's clearly not contact about the victim's children. That's clearly not contact about parenting matters. That's a direct communication to the victim to, people would argue, potentially influence how she would proceed on the case and whether or not she would ultimately cooperate, appear, and continue to move forward with prosecution. After the court modified that no contact order, we have those continued contacts, and it's no longer an alleged bond violation, it is a bond violation, submitted to it. So, Your Honor, the concern of the people is that the court gave this defendant the chance to have contact with his children while he was out, and he used that opening as a way to have contact with the victim. The people are requesting the remand.
Any response?
I have nothing further, Your Honor. I would just ask that Mr. Hook is on a GPS tether currently. To my understanding, there have been no violations of that whatsoever. These contact violations, which he has admitted to the second one, are the only alleged bond violations. We are asking that he remains out of custody so he can continue his employment as well as residing with both of his parents. His father is with him here today.
I gave him an opportunity. I mean, because typically I don't do that. When there's no contact, it means no contact. And I allowed him to have contact, written or electric, regarding the minor children only. And then there's contact that doesn't involve that at all. And so all he did was take advantage of the court's good graces in terms of doing that. And I'm not going to tolerate that, because what I should have done, if the children weren't involved in it, I would have just said, forget it. And I just wouldn't have allowed any contact whatsoever. And then I allow the contact and he abuses it. Defendant's bond is revoked, defendant's remanded.
Okay.